Hello, my name is Rick Fernandez. I'm one of the owners of Bowles Fernandez Law Firm. Very happy to have you visit our website today and to teach you a little bit about MERS. Those of you who are interested in finding ways to defend against a possible impending foreclosure may have heard of MERS, and if you look at your title, most people will see that MERS is on their deed of trust. And just take out that document, look through there, and you'll see some language that typically says that MERS is the beneficiary of this deed of trust, MERS is a secured party, MERS has certain rights, on and on. It'll talk about MERS as a very important part, and you may not know who MERS is. You may be wondering, who is this third party? I thought I took out my loan with US Bank or Wells Fargo or whoever. But in fact, you'll see that MERS is a player in your deed of trust, and now if you're facing foreclosure and you've gotten a notice of default, you'll be hearing more about MERS as well. So I'm going to talk a little bit today about what MERS is and why they are on your deed of trust and what issues that may raise in helping you prepare a defense against your foreclosure. MERS was founded in 1995. It was founded by a consortium of a number of big banks. If you can think of a big bank player, they'd be one of the people involved, including Freddie Mac and Fannie Mae, the two big government-sponsored entities. And some people may think that the reason it was founded, and this is the reason that they will tell you, is to make it easier in this electronic age to avoid having to deal with a bunch of burdensome paperwork, because every time you take out a loan, you'll recall that you signed a note, which is the IOU, and then a deed of trust, which is what's called a security instrument that secures that loan against the house. So in case you don't pay, they have the right, under certain circumstances, to take the house back. Well, MERS was founded, as they say, the founders say, in order to allow there to be an electronic database so that instead of mountains of boxes of paperwork, they could put all of it just on a database. Most of us are familiar with databases and how easy they are to just type a search in and you can find what you want. And that was the thought behind the foundation of MERS. The most important piece of that was, in Oregon, every time a note is sold, a promissory note, what we call mortgage, but we really mean is your loan. Every time it's sold, there's the deed of trust that you sign, the security instrument has to go along with that, because whoever has the security instrument, the deed of trust, can foreclose on that note under certain circumstances. So MERS was set up presumably in order to allow the easy tracking of notes, the loans that borrowers take out. The real reason, economic reason, and it often boils down to follow the money, the real reason behind MERS creation was to make it easy to take thousands of loans with all of their paperwork and sidestep the requirements associated with that paperwork and put it into what are called securitized trusts. And some of you may know the phrase mortgage-backed security. These were big pools of loans that were sold on Wall Street. And if you have followed the debacle that has happened in the housing market since 2008, you know that they were a major part of that. These mortgage-backed securities contained your loan, probably my loan, probably everybody's loans were packaged into these, then sold to investors who took profits based on how those loans performed. What MERS did was avoid having to, rather, MERS made it possible for the lenders to not have to record any of those assignments. Every time you sell your loan, a bank sells its loans, it has to also do an assignment of the corresponding mortgage or deed of trust that goes with it. So each time they have to do that, they also have to pay a recording fee to the county. So MERS really was a way to sidestep that whole process and save the banks literally millions and millions of dollars that they wouldn't have to pay to the counties around the country, so that they could simply maintain their own personal, private, internal database of these records. The problem with that is that rather than making the system more transparent, what it did was create a private parallel system so that a loan could be sold once, twice, 3 times, 4 times, and nobody would ever know in the public record, which is what the counties maintain, what happened to that loan. All you would see was the original deed of trust and then nothing after that, until the time the time comes that they may try to foreclose on that loan. Then MERS will go out and record an assignment from itself, because they will be That's why they're on the deed of trust. They are there to act as sort of a placeholder so that the real lenders who are buying the loan over and over in the background are never revealed. All you see is MERS name. So when it comes time to foreclose, if that time comes, then MERS simply does an assignment of that note, of that deed of trust, to the last party that's going to be the party that's foreclosing in their name. If you go to the MERS website, they have a public database. You can search on there, put in your MIN number, which you'll see on your loan if you have a MERS loan. MIN stands for MERS Identification Number. It's an 18-digit number that's used to track supposedly every conveyance of your loan through the history, the life of its history. But here's something really important to keep in mind. That information is only as accurate as the members of MERS input into the system. So if somewhere along the line one bank or another bank forgets or doesn't update the database, you will never find that information. And that, in other words, that information is not reliable. But it does give you a good starting point to figure out where your loan has been and who has it now. Now, why is MERS an issue in foreclosure, aside from what I mentioned, them being the party that does the assignment of your deed of trust to the final lender? Because currently in Oregon, the law is unsettled as to whether MERS can actually do any of this legally. Oregon law requires, and you'll see elsewhere on our website an explanation of how the Trust Deed Act works. In a trust deed, there are three parties. There's the lender, there's you, the borrower, and there's a trustee. So these three parties work together. The lender gives you money, you give the lender a deed of trust, and the deed of trust is held, conveys a legal title to your property to a trustee, who holds that title for the benefit of the beneficiary, is what that party is called. The lender is the beneficiary. Why? Well, if for some reason you decide, or for whatever reason, don't pay your loan, the lender can instruct the trustee to start a foreclosure process and take back title, so that the lender gets title to your house, and then they're able to sell it. Whatever they do in a foreclosure, sell it, keep it. But the three parties are essential. If you don't have the three parties, you don't have a trust deed. And the purpose of the trustee is to make sure that the lender is secured, because they're the party that gave the borrower, you, the money. MERS claims to be the beneficiary under your deed of trust, if MERS is on there, as well as numerous deeds of trust around the country. But can MERS be the beneficiary? And that's the open legal question that is in courtroom battles across the state currently. That is an open question. Our firm is very adamant in taking the position that MERS does not qualify as a beneficiary, and as such, MERS cannot play the role and assert the powers with respect to your loan that it currently claims to have. It's a complex legal issue, one that really deserves further analysis, both by the courts certainly, but also just from the homeowner's perspective, to understand what are the potential risks, what the potential defenses are if MERS is a party or purports to be, claims to be a party to your trust deed. That is the main reason why we as lawyers look to the MERS issue to see whether MERS is purporting to exercise powers that we believe they do not have under the Trust Deed Act. So we encourage you to take a look at your loan. That's one of the first issues we'd want to identify if MERS is involved in your loan. And then give us a call, and we'd be happy to follow up with a discussion about how this affects your particular loan. Thank you very much.